Afternoon, everyone, and it's a great pleasure to welcome you to this, the first of our series at Queen Mary, University of London, School of Law on Meet the Practitioners. My name is Elspeth Guild. I'm a professor of law at Queen Mary. I have been for more than 10 years now. And I have also been a practicing lawyer and a partner at Kingsley Napley. And it's a great pleasure to introduce you to this, our first of a series of conversations, which we're going to have over the next 5 months with practitioners about various aspects of immigration law in the UK and their impact in respect of law, policy, and individuals. Of course, there will be, of course, a very strong emphasis on what happens to people, but it's also very much about who works in the field, what do they do, and how do they interact both with one another and in respect of complex policy issues. I'm very pleased to introduce to you the two members of the panel. This conversation will take place between Nick Rollason and David Bolt, and I'll introduce each of them. Nick Rollason is the head of immigration at the London law firm Kingsley Napley. He has a very long and august career, having been involved in many of some of the most important cases in the United Kingdom in respect of immigration. He is highly rated in all of the law directories. You can look at Chambers or Who's Who, and you'll see that his name comes among the foremost lawyers in the UK in terms of integrity and accuracy of advice. He's also frequently consulted both by various parts of the British state, if I can put it that way, whether it be in Parliament or in the administration, but also by international organizations such as the OECD on immigration matters. He's going to pose some questions to our main speaker, who is David Bolt. He is the former Independent Chief Inspector of Borders and Migration, a post which is part of the public service. He served 2 mandates in that particular role and produced some of the most important reports which have changed our knowledge as part of civil society and more widely in the United Kingdom about how borders and immigration work and what the issues are. He did a groundbreaking report on the Windrush scandal and was the first report, and is still the most authoritative source of information in respect of data sharing, personal data sharing across the government for the purposes of immigration and border activities. His final report was just released. It's the annual report released in March 2021, which you can find on the website of the Independent Chief Inspector. And with his experience of over 20 years as a public service, both in the security service and elsewhere in the public service, he has a very deep knowledge of how the public service works, and also has had a very important role in this field of borders and migration in holding the public service to the highest standards of ethics applicable. Can I hand over now to you, Nick, to kick off? Those of you who have questions, we're going to have Nick and David are going to have a conversation for about 40 minutes, and then there will be a chance for you to pose questions. Please put them in the chat. And if you have a long question, please put in the chat that you want to pose a question so that I can ask you to unmute yourself and pose your question directly. Nick, I'll hand over to you now.
Thank you so much, Elspeth, and thank you for that very kind introduction for both me and for David. So thank you. So yes, as Elspeth said, we're going to be having a chat with David about his historic role as the now former inspector former chief inspector, and really just going over some of the many amazing things that he's done over those 6 years that he's left. Now, I would say before I start, David published a very helpful and useful valedictory report back in March of this year on leaving his post. And it really is a really helpful summary for those of you who want to see what David's achieved and the issues that he's identified, which he's very open about his interactions with the Home Office and with all the issues that he's had to deal with in trying to get information, trying to get things published. So really our discussion today is going to touch on some of those issues, but I do recommend it's a good read. Plus all the other reports that David has done, which have been fantastic and have really thrown a light onto what the Home Office does in its inner workings, its successes, its failures, and often, sadly, more often its failures than its successes. But you know, it has shone a very important light on that. So, David, I just wanted to ask you first, because some of the people on this call may not know about the role of the Chief Inspector, and I thought it'd be helpful just if you sort of introduced it by explaining the role, when it was set up, and the interaction of the Chief Inspector with the Minister and how that may have changed over time.
Sure, thank you, Nick. So the role, it's a statutory role which was created by the UK Borders Act 2007. It was in effect, it was the result of those of you who've got long memories may remember John Reid as the Home Secretary, who famously said that the Home Office was not fit for purpose in the way in which it was dealing with immigration and borders issues. And one of the consequences of his frustrations with the way in which things were working was the creation of the Inspectorate, as I say, as part of the 2007 Borders Act. I commend people to just to look at the 2007 Borders Act, it's section 48 onwards, because it does set out very clearly, I think, legislation sometimes is a bit confusing, but this is pretty clearly stated in language which I think is very accessible, what the role is. And the role is to examine the efficiency and effectiveness of anyone and everyone who is performing a function in relation to asylum, immigration, nationality, or customs for which the Secretary of State, the Home Secretary, has responsibility. So it's any official, it's any commercial company that may have been provided with a contract to support those functions. And indeed, it is the Secretary of State now herself, who is also subject to inspection. And as I say, the focus is efficiency and effectiveness, although that is a pretty broad notion. So it did allow me to poke my nose into quite a lot of things, which sometimes the Home Office argued were slightly beyond the remit and were around policy. But I'm sure we might come on to some of that detail as we continue the conversation.
And I mentioned that you felt that maybe the role has changed somewhat from what it was originally intended to be.
Yeah, I think that, and this is, one of the things which I think is, it took me a little while to recognise this myself. I was the second incumbent. John Vine was the first Chief Inspector. John served from 2008 until 2014. I started in 2015 and served until March of this year. In 2013, the department, the way in which immigration and borders was being dealt with by the department changed. So you moved from having the Borders Agency, which was an agency with a chief executive, to essentially the functions being brought back in-house into the Home Office, such that the Home Secretary was then directly responsible for the actions of the officials. And I think that changed the dynamic, where previously the Chief Inspector could be critical of the Borders Agency, and the ministers could essentially say, "Oh yes, we agree with you. And we're going to have give them a severe talking to." Now the criticisms actually came home to the ministers themselves, and I think that changed the dynamic and made some of those criticisms harder for the department to accept.
Yeah, I think I certainly think when you're criticizing the ministry, they take it very personally, don't they?
Yes, indeed they do. Yeah.
Okay, well, that's really interesting. And I think looking at your previous reports, I sense often a sense of frustration from you within the reports around access to data and access to information. And can you just talk us a little bit about that?
As Elspeth said at the beginning, my early career was in the security service, and that as an organisation, whatever people may think of it, one of the things that it was absolutely rigorous about was record keeping. So records, accurate, detailed records, was, as we used to like to say, the lifeblood of the service. One of the things that was most frustrating about dealing with the Home Office was just how poor record keeping is within the Home Office, and that meant that whenever I sought information or data from the department in respect of a particular inspection, it was extremely difficult to get to the information, because some of it actually didn't exist. It hadn't been recorded in ways that you would have imagined it should have been, and therefore simply wasn't accessible. But even when you were able to access the information, often it was not reliable. It was either patchy or sometimes internally contradictory, and that made for very sort of frustrating exchanges about why is it that information is so seemingly poorly regarded, and the record is so poorly regarded, because certainly in my judgment of it, if you're going to be making policy decisions, strategic decisions, you obviously need to have an information and database that you can rely upon. But equally, if you're going to make individual decisions, and obviously much of what the Home Office does in the immigration and borders world affects individuals, then again, you need to be absolutely scrupulous in ensuring that your information is as accurate as it can be. And so that was a great source of frustration.
So it sounds as though access to data sounds more like a cock-up than a conspiracy, in terms of just the data wasn't collected and maintained.
Yeah, I mean, I came across this very early on in my exchanges with the Home Office, and was very frustrated. But what frustrated me most was the sort of deliberate way in which the Home Office failed to collect the information. So when I did my first report on the hostile environment, which I now have to learn to call the compliant environment, but it was the hostile environment back then, and made recommendations in relation to the collection of data about the measures that were introduced in the 2014 Act, such that it was possible to in a sense, justify the fact that legislation had been passed to provide the Home Office with these particular powers. I actually got quite serious pushback. The Home Office did not feel that it was necessary, or in some ways, to some extent possible, to collect data to support the fact that these measures were in place. And so that was very frustrating. And coming back to that subject, on a number of occasions over the course of the 6 years, and making the similar points that actually there'd been a failure to do what was relatively straightforward in terms of just creating the information, the database, to be able to make the arguments. I think that was annoying. And if I sort of move forward to something like the EU settlement scheme, where the department had the opportunity from the off to create its own system that it could manage and measure, in whatever detail it needed. Again, there was a real failure to collect just basic information and data that would allow it to articulate what it was doing, and if necessary, to rebut any arguments that there might be that it wasn't working.
Yeah, no, that's interesting. And I think there's a lot of emphasis on statistical data, but less on sort of qualitative data.
Yeah, I mean, and you know, obviously it is more difficult to collect qualitative data. It's more challenging, but doesn't mean to say you can't do it. But it's more challenging than just numbers. But I mean, even the numbers were sometimes pretty flaky, I thought. So
yeah, thank you. And one of the things that I think you also mentioned in your report was the publication of your reports, because you do these reports, they're submitted to the Home Office, or whoever they're submitted to, but I think you were concerned about, some of the reports being delayed, squashed. The government has a very bad track record of squashing reports. It doesn't want to come out at a particular time. I mean, how did you feel that impacted on your role?
Yeah, so my predecessor, up until 2013-14, published reports when he chose to do so. So he had power of publication. The Home Office got quite grumpy with him, and I don't know particularly which report or series of reports it was, but in 2014, the Home Office sought advice from government lawyers about the interpretation of part of the 2007 Act, and particularly a clause in relation to publication. And the government lawyers made the argument that, in fact, what had been happening was the wrong way for things to have been handled, and in fact, the Home Secretary should have power of publication. So in 2014, the power of publication was taken away from my predecessor, and so I inherited a system where the Secretary of State, in practice, laid reports in Parliament, and at the point at which they were laid in Parliament, I could then publish them on the website. When this change took place, the Home Secretary at the time, well, I think it may have been the Immigration Minister, but on behalf of the Home Office, told Parliament that it would publish within 8 weeks of receipt of reports, which is the sort of convention that applies, I think, for when select committees ask for responses from ministers. It's within 8 weeks. So that was the notion. I think, in the course of 6 years, I had 81 reports published. I reckon I could count on the fingers of maybe both hands the numbers that actually met the 8 weeks. I think the record was 53 weeks. And last year, the average was 23. So 6 months.
And is there a correlation between how controversial the reports were and the delay?
I wish I could see some logic. Other than I suppose the longer it takes to publish, maybe the easier it is to argue that was then and this is now and things have changed. But I said very early on, and I said it to successive Secretaries of State and permanent undersecretaries, that I wasn't too bothered about the business of who published, and I wasn't too bothered about even the 8 weeks, although I think that that was important for transparency, for public access to the information. What I was bothered about was that when a report was submitted with recommendations that broadly the Home Office agreed with, it didn't just get on with implementing those recommendations when it received the report. It actually waited until the report was published before it started doing something. And that, I think, was a waste of time. So I had conversations with successive ministers about the effectively win-win of being able to say, the Home Office being able to say, we received this report in whenever, and we immediately started doing this, that, and the other in order to implement these improvements. It would prove that the department was agile and was responsive, and it would prove that the inspectorate was effective. A number of ministers said, yes, we agree. We think it is win-win, and nothing changed. So.
Yeah. Okay. Thank you, David. Well, I think that's really helpful kind of overview of some of the challenges you've had in terms of your role in a sort of structural way, access to data and publication and your role. I just wanted to focus in a little bit more on some of the kind of key issues that you've seen over the years. And I think, you know, some of the things that you've touched on, obviously the Windrush report, which, you know, threw a light on a culture of, you know, within the Home Office and the hostile environment or compliant environment, as you say, those sorts of reports. You know, is there anything that for you particularly stands out as one of the most controversial things about, you know, your work? You're seeing what the workings of the Home Office are, and that hopefully some of your recommendations change that potentially.
Well, there are a number of things which I suppose sort of stand out in my mind, in a number of things that I looked at, some of which affected change and some of which sadly didn't. I mean, I would say that early on, I was initially appointed for 2 years, and within 6 months or so, that was extended to 5 years. And I was encouraged by, it was Theresa May as the Home Secretary at the time, to take a more strategic approach to the business of inspection. So I designed a program that would try to look as broadly as possible across the different parts of the immigration and borders functions, and try to draw out the, if you like, the strategic strands that connected those things. And again, you mentioned my valedictory annual report. Some of those are detailed in there, but they were around things that some of which I've mentioned before, like record keeping and just doing that quality assurance and making sure that decision making was actually quality assured by first line managers, so that bad decisions didn't go beyond that and didn't get issued and then, you know, lead to problems further down the track. Things like the sort of coherence of the system, so that bits of the department talk to one another in a sensible sort of way, so that you didn't have left hand, right hand. There were a number of things which were just basic, the sort of basic things that any large organization needs to get right, you know, just to function efficiently and effectively. And those, in a sense, those issues came through in you know, pretty much every inspection, whatever the topic, whether it was looking, you know, at the controls at an airport, or whether it was looking at the functioning of some part of the immigration you know, policy systems. But in terms of things that I looked at where I think I did manage a little bit of impact, administrative reviews were introduced as an alternative to appeals, a whole swathe of appeals. Actually, in the 2014 Immigration Act, but 2015 there was a requirement for the inspector to look at how they were functioning after 12 months. And so I looked at this new system for admin review, which in theory was going to give a much quicker, cheaper, more efficient and effective way of people lodging concerns about decisions that the department had made about, you know, immigration decisions essentially. And so I looked at it to see what, you know, was it working, and frankly it wasn't. It was a muddle. There were different systems operating in different parts of the Home Office with different considerations being applied. And so I made some recommendations which were really around trying to consolidate the way in which it was dealt with, to make sure that the separation from the first decision maker to the reviewer, that separation was made clear, so that it was a proper, as far as an internal system can be independent, it was an independent view that was being applied. So there were some fairly significant changes to the way in which the Home Office managed that in 2016-17, and the way it resourced it as well, with slightly more senior people making the decisions. I have to say, sadly, I mean, I went back again in the last 12 months to see how that admin review system was operating. And it was operating actually pretty well as a a process. Things were moving through the system in the timescales that they were supposed to. But it was falling down badly, I thought, in terms of those admin reviews that related to challenges to credibility. So it dealt reasonably effectively with, if you like, technical problems with the decision, but it really didn't deal very well at all, where the original decision had an element of credibility judgment in it, where the admin reviewer really simply reiterated the original decision. So in the valedictory report, I sort of challenged the department whether it was now time to go back to the original intention behind that admin review system and ask some serious questions about whether or not it actually had achieved its purpose. And I don't see much appetite for it, but it may come on to another subject which we might talk about, which is how issues might be taken up, by parliamentarians rather more effectively, and challenged. And it seemed to me that back in 2015, there was pretty heated debate in Parliament about the introduction of these new admin review arrangements as distinct from right of appeal. But actually, there's not much parliamentary interest in the subject at all now. And I think
it's completely off the agenda, and we continue to see, very shallow decision making around things that affect people's life, with really quite cursory dealing with technical issues on caseworking, and people being told there is nothing wrong with this decision. I think probably you found that about 80% of admin reviews are rejected.
Yeah.
So when you're looking at those sort of statistics, you can recognise how narrow the window is to get through that system. But yes, no, that's really helpful. And a few other things that I wanted to sort of talk about in your experiences. One of the things you touched on in one of your reports, and that a lot of people have been very worried about, and you mentioned decision making and quality of decision making, is to do with artificial intelligence and AI, the use of AI in decision making, which people were very concerned about discovering that AI was being used. I mean, could you talk a little bit about that?
Yes. So in particular, in relation to, I suppose there are two areas which I've looked at that is worth mentioning. One of them is the electronic gates at airports, which people with now over 12-year-old and above are able, if they're from the right countries, to be able to use these electronic gates. And the concern there, I think, was really one of vulnerable individuals who are able to enter the UK through gates without any real check or any intervention from Border Force that might identify, for example, victims of modern slavery or others who may be being trafficked, or in some other ways may be vulnerable, which you would hope that if they were to go through a control desk, that would be something that would be picked up, or at least there would be a greater chance of it being picked up. So I am a bit of a Luddite, but I'm not entirely a Luddite, and I recognise that in order to manage the volumes of people arriving in the UK and to manage volumes of applicants for visas, there does need to be a proper use of technology, and so it's right and proper. I think that the Home Office is looking at technologies that might help it with dealing with the volumes, but it needs also to make sure that it doesn't, in the same process, lose some of the safeguards that exist when those decisions are being dealt with, by individuals rather than by machinery. On the visa side, the issue that came up was the so-called streaming tool, that I got very frustrated with the Home Office about the streaming tool. The streaming tool, essentially, in sort of very briefly, is a means by which visa applicants from any country are streamed according to traffic lighting, red, amber, or green, and according to the stream that they're put in effect, the decision maker about whether or not the visa should be granted pays more or less attention to the case. So green cases are considered to be relatively straightforward, and therefore I wouldn't say that they get a cursory look, but they get less attention paid to them, whereas red cases are supposed to be given rather more attention and possibly challenged. And I actually found that when I sat down in Croydon with some decision makers, particularly those dealing with the red stream cases, that actually, and I don't think it was just because I was sitting next to them, they exercised quite considerable care over the way in which they considered the individuals who had made the applications. You may make some sort of arguments about whether or not they should have been red streamed or green streamed anyway, but nonetheless, the ones that had been red streamed weren't automatic refusals. I did see cases that had been red streamed that were granted. But I think the issue really that I came up against with the Home Office was its refusal to explain the way in which the algorithm was working to the wider public, in order to try to deal with some of the quite natural concerns that were being expressed by people, including APPG Africa, who were very concerned about the extent to which the streaming tool was affecting decisions about applicants from African countries. And actually the Home Office had the opportunity, I thought, to debunk some of the concerns, because actually some of the concerns were misplaced. But it chose not to, hiding behind an argument that said that if it were to explain in more detail how the thing worked, then people would find workarounds. And I found that was just silly, actually, and unhelpful. So I think the issue with AI is not that it should be set aside and never used. It is that if it's going to be used, the department, Home Office, or any other department for that matter, owes it, I think, to the public to explain, in some detail, how it works and what it achieves, what its limitations are, what the safeguards are for using it, and how it's going to be applied. And if it can't do that, then inevitably it does raise concerns.
It's taking us back to the dark days when no immigration directorate instructions were ever published, and so one never knew how people made decisions until they were published finally, and now they're they were published, and then now what you find is that they're actually much less full than they might be. Because people don't want too much detail, because they say if you know everything about how these decisions are made, then you game the system. But it's a very similar very similar thing, I think, with AI.
Yes, I agree with you. I mean, on the publication of guidance, you're right. There is now much more guidance that's accessible, but I hit some quite sort of serious problems trying to get particularly border force guidance to be published, because that is still protectively marked often. And actually, I could have access to it, but it was protectively marked. And I struggled on a number of occasions to see what on earth it was that meant that it needed to be protectively marked. And it was only, I think, this general sense that we really don't want to have to explain ourselves and how we operate.
Yeah, no, I think that's really helpful. Thank you. And I think we're sort of nearing the end of our sort of 40 minutes probably, but we're nearly there. But what I wanted to just, a couple more questions that I had for you. One was just on the culture of the Home Office. I think, a lot of people read news stories about the Home Office we've seen the Windrush, the lessons learned and the comprehensive improvement review that's taking place about the Home Office and decision making and the culture. What's been your experience of the culture within the Home Office, and is it as bad as it's often portrayed in the press? What's the inside track you can share with us?
Well, I think the first thing to say is that I don't know what the exact number is these days, but there are roughly 25,000 officials working on borders and immigration functions within the Home Office. They are split around 200 plus sites, and the functions that they perform. I tried at one stage to create a grid that would have the places that they functioned down one axis and the sorts of functions across the top. And it looked like, for those of us that are old enough to remember Mr. Littlewoods and his pools coupon, it looked like a pools coupon. It was just so vast. So I think the thing I would say is there isn't one culture. There are lots of cultures across the Home Office, and sort of micro cultures, if you like. And you go to, you go to Portsmouth, for example, to the port there, and there'll be a different sort of culture, to Dover, because there are different people, and okay, they're performing the same function, but it's culture comes not just from the function that you're performing, but from the people around you, and your so I think I wouldn't say that the Home Office, when it signed up to Wendy Williams' recommendations around the work that it needed to do on culture, I wouldn't say that it underestimated what it needed to do, but I think it may have been slightly optimistic about how easy it would be ultimately to create a single cohesive culture. I think it can achieve certain things which you might say are around culture, like the face behind the case training, the extent to which it can roll that out across the whole department, so that there is at least some sort of common language and understanding of things like that. But to create a single homogenous culture, I think would be a real challenge.
Yeah, and I think that's right, because my experience of some bits of the Home Office are they're highly professionalized and very focused on good decision making and good interactions with applicants, and others don't care a damn about the applicants.
Yeah, well, I mean, but you only have to look at something like, and I know it's no longer operating, and we've got the Afghan scheme, but you only have to look at something like the vulnerable person scheme, the Syrian scheme. Yeah. And talk to the people involved in that, and I did a lot of work around that, and was at Birmingham Airport when flights were arriving, and people were then really excited and happy about the Home Office staff, about the work they were doing to support these vulnerable people and to open up these new lives for them. That's a fundamentally different function from being an immigration enforcement officer going around nicking people who are working illegally. It's knocking down the door. It's a different function.
Yeah. And David, my last question really for you is, as you've now left and you've handed over to your successor, really what you wanted to say to them in terms of the key things that they should think about on the job, maybe some top tips for them going forward about what makes a good chief inspector and how to deal with the tough bits.
Yeah, I mean, you need to be sort of fairly bloody minded and persistent, I think, and not get put off easily by the department. So I think being dogged is important. It was a great job in the sense that it was, I had free reign, really. I could choose exactly what I looked at, how I looked at it. I wrote all the reports, so how I would express it, what I might recommend. So from that point of view, it's an incredibly privileged position to be in. I recognized, and I know my predecessor recognized that meant great responsibility in terms of trying to ensure that you could represent the widest possible interest. So I ran a variety of stakeholder groups to try to ensure that I understood as many perspectives as possible. We opened up the notion of calls for evidence on the website to try and get things, but I still felt that I still didn't know as much as I would have liked to have known, even after 6 years, about how the department operated and how it affected people. My advice to, clearly it's important to keep continuity, so he's called David as well. My advice to my successor, was, enjoy it. It's tough, but it's a tremendous job. But you need to sort of keep at them. And also, and this was maybe a slight insider tip, when the department says to you, when you say to it, I think I'm going to inspect this thing, and they say to you, oh, well, the timing's not great. Maybe if you came back in, say, 6 months or a year. The first couple of times they said that to me, I thought, okay, that sounds fair enough. After that, I didn't. So I did encourage him not to be too easily persuaded, or dissuaded rather, from looking at things.
Yeah. You underlined the word independent, I think, when you were saying that, probably.
Yeah.
Okay. Well, look, David, it's been fascinating talking to you. I know we got some questions in the chat, and I'm going to hand over to Elspeth to maybe ask you her own questions, because I'm sure she's got lots of things that she might want to ask you. But also, there's a few questions in the chat around the immigration rules and immigration detention. So I'll hand back to Elspeth. Thank you, David.
Thanks, Nick.
Thank you so much. And that's been such an interesting discussion. I think that the way in which you've designed the questions and you've dealt with them have opened up an enormous number of avenues for further consideration, further debate. And you've both been terribly, terribly disciplined in not heading off into the underbrush, which I'm sure was tremendously tempting at various times when there's such a wealth of detail in respect of this. So thank you so much to both of you. And I think that you're both included in the questions that we've received so far. So Nick, I don't think these are just questions for David. I think they're also questions where you may well have things that you want to add. The first one is from Warren Simmons, who asks a question about the EU Commission GDPR adequacy decision. And this has come up about 3 times in the last 4 days in different events that I've been at. I think there's been a certain jubilation in some parts of the world and horror in other parts of the world about this adequacy decision, which is so important for the British economy. But the question is really about the carve out of data transfers in relation to immigration controls. And really the question which they're asking, and I think this is definitely for both of you, is whether you think this is a big spanner or a minor bump in the Home Office data transfers. Does it reflect concern over a Court of Appeal judgment in May 2021, which looked at the lawfulness of procedures relating to data transfers? So I think this data transfers issue is a very big one. And I know, Nick, you've looked quite a bit at the EU agreement with the United States, Australia, and a couple of other countries about data transfers, personal data transfers from the Home Office as well. So can I hand over to you to comment perhaps on this carve out in respect of the EU's GDPR adequacy decision?
Yeah, thank you, Elspeth. Yes, so a few years ago, I gave a lecture as part of one of your master's courses, Elspeth, on this issue of data protection and transfer of information between the UK and other Five Eyes states in the context of immigration. And I asked the first question I asked the people in the room and many of whom were on what were then Tier 4 visas, doing their masters, do they remember signing the immigration form? Did they remember what it said? Do they know what's happening to their data? All that very personal information in that form, including their parents' details and goodness knows what else, and all the information they provided. And the answer was, well, we're quite used to giving out our data, but this is very, this is data which is not used by Amazon. It's used by other states that the UK works with in securitization of information. And I think this decision in the Court of Appeal is obviously it's a blow, because I think people were hoping that the exceptions in the GDPR regulation, which allow certain information to be shared, and its exceptions of the usual GDPR rules for public security reasons and criminal reasons, that the argument was, well, that doesn't really cover immigration, because immigration isn't about crime and it's not about security. But unfortunately, the court said, well, the immigration exception is lawful. So I think I have to say, I don't think it's surprising, because the ambit of the security general exception is so wide that the courts tend to not to want to interfere too much with that. But that's my view. I was obviously disappointed, but I think most of the people on this webinar will also be disappointed. But David, I don't know if you had any thoughts about that as well.
I have to say that it's not something that I looked at. The exchange of information with other countries wasn't something that I was particularly focused on. I look rather more at the way that the Home Office shared data with other government departments in the UK, and that was more of a focus for inspection. It does, I suppose, touch on the point that I was making earlier on, which is the concern that I would have that Home Office information and data is accurate, and obviously, if it's intending to share data with other parties, and that data is in some sense unreliable, then that could lead to concerns that actions would be taken that should not be. So I would sort of come back to the bit that I know about, which is the Home Office information that it holds in relation to immigration is needs some hard work in terms of ensuring its accuracy, the fact that it's up to date, the fact that it's sort of managed in an effective and efficient way, and it needs to get its house in order, I guess, before sharing.
Yeah, I just add to that, David, that our data protection rules can actually be a very useful tool for migrants, particularly if it's not so much the sharing of information, it's about the accurate records. Mm-hmm. And what we find is that a lot of people get stopped at immigration based on inaccurate records, incorrect information. Yeah. And you can ask them to correct the information under the GDPR, and try and get blocks removed in sometimes. So it can be a useful tool, but I don't think the Home Office quite see data protection as a way of sort of correcting the immigration record. They see it as something else.
I think this is an absolutely enormous question, and I certainly think that the European Commission's adequacy decision and the carve-out for immigration is a bit of a shot across the bows about exactly these kinds of problems, that there's far too little control over Home Office sharing of data with other ministries, but also in a wider sense, and that the accuracy of that data is not subject to a sufficient number of requirements. I remember Evelyn Brouwer, when she was looking at information in the Schengen Information System for refusal of entry, when she went and actually interviewed data protection officers in 5 member states, including, of course, Germany and France, she discovered that according to them, over 40% of the information which their government had put into the Schengen information system was either incorrect or unlawful. So that's in a system which had a very high level of security interest in it. And still, the data protection authorities considered that what their governments were stuffing into that system was highly inadequate. So I'm not surprised about the carve out, but I'm not quite sure where it's going to take us. I think, Nick, that your comment about further sharing without controls may be part of what has informed the Commission's decision to make a carve out. And of course, the Court of Appeal judgment didn't help that in any way at all. There's another question, again from from the chat, which is directed to David, which is whether you have any views on immigration detention and whether it should be reformed, modified, or altered. And David, I know you have an awful lot of reports which have focused specifically on that, including one of the very recent ones on adults at risk.
Yes, so I was invited by the Home Secretary, not the current one, the previous one, to review the workings of the adults at risk policy, so adults at risk in detention policy, on an annual basis, following a couple of reviews or a couple of pieces of work done by Stephen Shaw to look at vulnerability of individuals in detention. And I was grateful for the opportunity to be able to become more directly involved in issues of detention, because in the legislation, the operation of places of detention is actually cut out from the functions of the Chief Inspector and is a function of the Prisons Inspectorate or the Police Inspectorate, to the extent that people are held in police custody. So the invitation to look at adults at risk was essentially an invitation for me to go into the detention estate and to have a look at how all of that was operating. Obviously, with COVID has changed things significantly over the last year or so. But what I found when I looked at detention, particularly looking at vulnerability, was that there were a lot of people who were in detention who, for whom there was really no realistic prospect of any sort of early removal, which was obviously one of the conditions of detention. And that the process that the Home Office had put in place to review cases of individuals who were in detention to judge whether or not their detention should continue or they should be released was wholly inadequate. It simply didn't work. So much so that I didn't actually wait until I produced my report on adults at risk. I actually wrote separately straight away to the Secretary of State and to the relevant Director General in the Home Office to raise my concerns about what are called case progression panels and the way that they operate in considering the cases of individuals in detention. So, as I say, that sort of changed significantly because of COVID, and a lot of the people who were in immigration removal centres who were being detained for extended periods with a view to removal, but with no obvious prospect to do so. A lot of those people were released. My report, though, also focused on the other cohort, if you like, which are foreign national offenders, many of whom are actually detained in prisons, but under immigration powers post the completion of the custodial sentence. And they were very much sort of second-class citizens in this whole detention issue in terms of the considerations given to their release. And I think that situation has not really changed. And the second review of adults at risk has focused again on the failure, I think, of the Home Office really to look seriously at the ways in which foreign national offenders are being managed within the prison estate. And the fact that, that things like the Rule 35 conditions that apply for immigration removal centres, the so-called equivalent of Rule 21 within the prison rules just doesn't work. I mean, there are no cases where individuals have been released on the basis of health or concerns about their vulnerability under the prison rules. And indeed, the numbers of FNOs have gone up since the pandemic. So that's also a concern. So yes, I do have considerable concerns about it. I think I've worked with various organisations like BID and others who clearly are very concerned about this whole issue of detention. And I think the Home Office has got some pretty serious questions to answer about it.
Nick, did you want to add anything to that?
No, I think David said it all. I think I agree with everything David says.
Well, I think we still have a number of questions in the chat, but we've come to the end of our allotted time. So as we are a university, we believe that time is extremely precious and is the commodity which in respect of which we sell our services. I'm going to call this to an end, but I want to thank both of you enormously for the questions, for the candor in both the answers and the commentary, and providing us with a real insight into how practitioners work in a highly contested field, not always in a setting which is without friction, and in respect of which you seek to provide the best possible outcomes, both through mediation, through transparency, and through practice for migrants and people who are in need of our services. So thank you so much for this excellent webinar, for kicking off our series with such an exciting set of discussions. And I wish you a very nice evening. And thank you to all of you out there who've joined us. I hope that this has been interesting. I'm sorry that we didn't get to answer all of the questions, but that's an inevitability.
And Elspeth, can I just say thank you to David for all his really excellent work over the years. It's been really brilliant. And you have thrown a spotlight on lots of areas of the Home Office. So thank you very much for your work on that.
Well, thank you for saying so, Nick. I mean, I think just a sort of final word from me. I mean, I think part of the function of the inspector, and I didn't really know this at the beginning, is to try to ensure that information is shared with the public about how things are working. And I alluded to parliamentarians earlier on. I mean, one of the things that I hoped would happen and probably didn't as much as it might do, and I'd encourage people on the call to sort of pursue this, is when reports come out, the inspectorate can do a certain amount in terms of encouraging the Home Office to adopt recommendations. But it's really for others, I think, to pick up on the information that's in those reports and to make use of it in whatever ways they can to advocate for change. And so I've just encouraged that. Some of the reports aren't necessarily the most exciting things you'll ever read, but there's got a lot of detail in there, and it's important stuff to really sort of press the department on.
Thank you.
Thank you so much. And David, you should know that in my students' essays last year, quite a number of them cited more than one of your reports as the sources of information, which were not otherwise available. So certainly at least students who were doing my courses are reading your reports with great avidity.
Well, I'm pleased to hear that. I did wonder at one stage whether I wrote them and I read them, and that was about it.
No, we
Thank
can
you.
assure you. You are cited. It's the evidence that you exist in the academic world. Thank you very much, and goodbye to everyone.
Goodbye.
Bye. Thank you. Thanks, Elspeth.